Be ready? Start. In the case in hand, the learned Munsif rejected the execution application on the ground that the decree holder took no other steps for proceeding with the execution. Stop. Quite obviously, the execution application was not fixed on 11th July 1980 for its hearing. Stop. The petition number 49/11 filed by the judgment debtor was fixed for hearing and that petition was rejected on that day. Stop. After rejecting that application, the court below further passed an order dismissing the execution case for default on the ground that the decree holder took no other steps. Stop. This order was obviously not covered by the provisions of Rule 105 of Order 21 Code of Civil Procedure. Stop. Hence, the provisions of Rule 106 could not be invoked. Stop. The decree was passed on 4th March 1968. Stop. The period of 12 years had expired on 4th March 1968. Stop. The execution application was dismissed on 11th July 1980. Stop. In these circumstances, the decree holder filed an application under Section 151 Code of Civil Procedure for recalling the order of 11th July 1980 instead of filing a second application for execution. Stop. I have already pointed out above that the provisions of Rules 105 and 106 of Order 21 could not be invoked on the facts and circumstances of the instant case. Stop. There is no other express provision in the Code of Civil Procedure dealing with the situation which had arisen in the present case. Stop. The trial court had not fixed the execution application for hearing on 11th July 1980. Stop. It had fixed that date for hearing of the petition of the judgment debtor whereby he wanted the stay of the execution proceedings till the harvesting was done. Stop. That application was rejected by the court below as it had become infructuous. Stop. The parties were present before the court. Stop. If any steps were required to be taken by the decree holder for proceeding with the execution, the court should have granted time for doing so. Stop. Instead, the court below rejected the application in default. Stop. The decree holder therefore applied for setting aside that order. Stop. Such an order not being covered by Rule 105 of Order 21 Code of Civil Procedure, the application for setting it aside could not be filed under Rule 106 of Order 21. Stop. The inherent power of the court was therefore invoked to set aside that order. Stop. The court below, having found that there were sufficient grounds for setting aside that order, recalled it and allowed the application of the decree holder and fixed 24th July 1980 for taking steps in the case. Stop. Such an order could not be said to be capricious or arbitrary. Stop. The discretion exercised by the court below in setting aside the order dated 11th July 1980 could not therefore be interfered with. Stop. In fact, the impugned order was passed in the interest of justice and taking, of course, the notice of the fact that the alternative remedy to file a fresh execution application had become barred by time. Stop. The petitioners have thus failed to make out a case warranting interference under Section 115 of the Code of Civil Procedure. Stop.